Start. In view of the above, the trial court has, after considering the evidence on record, come to the conclusion that the petitioner husband has been able to prove the ingredients of section 13 within bracket A of the act, and the petitioner husband is entitled to a decree of divorce in this behalf, full stop stanza. Being aggrieved and dissatisfied with the said judgment, the respondent wife filed appeal being regular civil appeal number 189 of 1999 before the joint district judge on 13/7/1999, full stop. The joint district judge at Gandhidham by his judgment and decree dated 15/12/1993 has held that the trial court has erred in holding that the respondent wife has committed an act of cruelty towards the petitioner husband by abandoning the petitioner husband, and the petitioner husband was entitled to obtain a decree of divorce, full stop. The learned appellate judge also held that the learned trial judge has not properly considered the fact that decree of divorce granted by the trial court is improper and illegal, full stop. The learned appellate judge has held that if a woman gets good designation or good job on the strength of her education, and if a husband is not earning good income and is residing at another place after the marriage, wife cannot be compelled according to orthodox Hindu mythology to leave her good services or status and to stay at the husband's place, full stop. If a woman refuses to do so, she cannot be called upon to be ready for divorce, full stop. If it is so acted upon, it would be an insult to the woman's pride, and it would amount to denial of a woman's right of equality, full stop. In view of the same, the learned appellate judge has held that it cannot be said that the wife has abandoned her husband or has committed an act of cruelty towards the husband by abandoning the husband, and the husband was entitled to obtain the decree of divorce, full stop stanza. This matter was heard on 24th and 26th December 2001, full stop. Arguments were over, full stop. However, at that time, both the learned counsel stated that before the court pronounces the judgment, they may try to settle the matter, and if need arises, both parties will come to this court, and this court can inquire about the desire of husband and wife, full stop. Due to paucity of time, both could not come to this court, and ultimately on 15th January 2002, both husband and wife came to Ahmedabad, and I have called both the parties in my chamber jointly, and thereafter I have heard them in my chamber independently, full stop. I have requested both the parties to join together and live together happily as husband and wife in the matrimonial home. But unfortunately, both parties were adamant and the matter could not be resolved, and that is why I have to give the judgment stop.